This is about Tobias v. Abalos, GR number 114783, December 8, 1994. Once the neighboring municipalities of Mandaluyong and San Juan shared a single legislative district. Their representative in Congress, Honorable Rolando Zamora, took the initiative to sponsor a bill that would eventually change Mandaluyong's status. This bill aimed to convert the municipality of Mandaluyong into a highly urbanized city to be known as the City of Mandaluyong. On February 9, President Ramos signed RA number 7675 into law. Following the Local Government Code of 1991, a plebiscite was conducted on April 10, 1994, specifically for the people of Mandaluyong. They were asked to vote on the conversion. Despite a lower voter turnout of only 14.41% of the voting population, a clear majority of 18,621 voted yes, while 7,911 voted no. Based on these results, RA 765 was deemed ratified and took effect. However, not everyone agreed with the new law. A group of taxpayers and residents, including Robert Tobias, challenged the constitutionality of RA 7675 before the Supreme Court. Their main target was Article 8, Section 49, which declared that Mandaluyong, as a highly urbanized city, would have its own legislative district. Consequently, the remainder of the former San Juan Mandaluyong district would become the new legislative district of San Juan. This change meant both new representatives would be elected in the next national elections. The petitioners raised three specific constitutional objections, primarily related to the legislative department. The petitioners' primary arguments concerning the legislative department involved: number one, the one subject, one bill rule; number two, the constitutional limit on the number of House members; and the third one is the congressional power of reappointment and the necessity of a census. The Supreme Court discussed these subject matters as follow. On the first issue, on the violation of the one subject, one bill rule, it's on Article 6, Section 26, Paragraph 1 of the Philippine Constitution. The petitioners argued that RA 7675 embraced two distinct subjects. The first one is the conversion of Mandaluyong into a city and the division of the congressional district. They claimed that the latter was not germane to the law's title. The Supreme Court found this contention devoid of merit. It agreed with the Solicitor General that the statutory conversion of Mandaluyong into a highly urbanized city with a population of not less than 250,000 inevitably ordains compliance with the one city, one representative provision in Article 6, Section 5, Paragraph 3 of the Constitution. The court explained that the creation of a separate congressional district for Mandaluyong is not a distinct subject, but a natural and logical consequence of its conversion into a highly urbanized city. The title of RA 7675, an act converting municipality of Mandaluyong into a highly urbanized city of Mandaluyong, necessarily includes and contemplates the creation of a separate district. The Supreme Court further emphasized its long-standing practice of adopting a liberal construction of the one title, one subject rule to avoid impeding legislation. Citing previous rulings, SC stated that the constitutional requirement is sufficiently met if the title expresses the general subject and all provisions are germane to that general subject. The title does not need to mirror or catalog all minute details, but it must inform legislators and the public of the nature, scope, and consequences of the proposed law. Now, on to the second issue, on the increase in the House of Representatives beyond the constitutional limit as stipulated in Article 6, Section 5, Paragraph 1 of the Constitution. The petitioners argue that the division of San Juan and Mandaluyong into separate congressional districts, as mandated by Section 49, resulted in an increase in the composition of the House of Representatives beyond the constitutional limit. The Supreme Court again found this argument without merit. It highlighted that Article 6, Section 5, Paragraph 1 states that the House of Representatives shall be composed of not more than 250 members, unless otherwise fixed by law. The Court clarified that the unless otherwise fixed by law clause explicitly means that the present composition of Congress may be increased if Congress itself so mandates through a legislative enactment. Therefore, the increase in congressional representation resulting from RA number 7675 was not unconstitutional. On the third issue, on the lack of census and preemption of congressional reapportionment, as stated in Article 6, Section 5, Paragraph 4 of the Constitution, the petitioners asserted that the division was not made pursuant to any census, showing that Mandaluyong and San Juan had attained the minimum population requirements. They also contended that Section 49 preempted the right of Congress to reapportion legislative districts. The Supreme Court said that the absence of mention of a census in the law does not suffice to strike down its validity. RA 7675 enjoys the presumption of having passed through regular congressional processes, including due consideration by the members of Congress of the minimum requirements for establishing separate legislative districts. It is not a requirement that all laws contain all relevant data considered during their enactment. Concerning the claim of preemption, SC found this argument to border on the absurd. It pointed out the glaring fact that Congress itself drafted, deliberated upon, and enacted the assailed law, including Section 49. Therefore, Congress cannot possibly preempt itself on a right that pertains to itself. Additionally, the Supreme Court addressed other arguments. The petitioners contended that the people of San Juan should have participated in the plebiscite. The court found this bereft of merit, explaining that the principal subject of the plebiscite was the conversion of Mandaluyong, and the matter of separate district representation was only ancillary. Thus, the inhabitants of San Juan were properly excluded as their status was not changing. The petitioners also claimed gerrymandering. The court deemed this not worthy of credence because the author of the law, Representative Ronaldo Zamora, was the incumbent representative of the former San Juan Mandaluyong district and had consistently won in both localities. Dividing the district actually diminished his constituency, which would hardly be favorable to him. Ultimately, the Supreme Court dismissed the petition for lack of merit, allowing RA number 7675 and its provisions, including the creation of separate legislative districts, to stand.